All right, welcome back. So next section is on commercial leases. So we alluded to in our earlier example, residential leases, right? Doesn't have to be a residential lease. Generally, you have two types of leases, namely a commercial lease and a residential lease. That is important in that the legal principles, as we'll see, are different. A commercial lease usually is a purely contractual instrument in that you can do whatever you want. So you can have terms that are designed as you want. Of course, subject to the various limitations that we saw earlier. So if it's not a sufficient property interest, right, it will be a license, therefore won't count as a lease at all. To the extent that you have sufficient exclusive possession, you can have whatever you want as the term. So you can have a contract that, right, favors the landlord. For example, it says, right, if you don't pay, you have a penalty of $2,000. On top of that, I get to show up with 2 days' notice. It would be allowed. It's a contractual instrument. So to the extent that you create or transfer an estate, a leasehold estate, within the meaning of the definition in property law, you do transfer property interest. The nature of it can be limited as much as you can on that, right, continuum we just discussed. There's nothing that says it's got to be fair. There's nothing that says it's got to favor the tenant. So usually a commercial lease will be more easily tailored to the specific interests or circumstances of the party, as opposed to a residential lease, as we'll see, which will have usually far greater statutory regulation. That is a modern evolution of the law, right? It's because we've decided that residential leases are actually important, right? Because they're places where people live. They're not just consumer goods, and therefore we protect people. We say you can't evict them unless certain conditions are met. You can't charge them whatever you want. You can't force them to pay 12 months ahead of time. Or sorts of things. Again, these are not inherent property law concepts. They don't come out of the case law from 200 years ago. They're statutory obligations, right? Namely, someone in the Ontario legislature woke up one morning and thought tenants needed to be protected because they're important people. Therefore, they passed a law that says tenants are protected, and for these protections to apply, the lease has to be characterized as a residential lease. That's what the statutory definition will say. And then you'll have all the obligations we just discussed apply. That's why it's important, right, to make that distinction between a commercial lease and a residential lease, because these statutory obligations will apply. Okay, another thing we'll just mention briefly is a periodic tenancy, which you'll recall was important earlier in the term for the purposes of applying certain principles that we saw having to do with adverse possession. So we said if you have a lease for 10 years, right, then you enter into a tenancy at will if you stay there. So it's for 10 years. After 10 years, you don't leave. To the extent that the landlord has not rented it to someone else, in which case they can kick you out, you are in a tenancy at will. You have to pay monthly, same amount was in your lease, and the tenancy goes on until, again, the landlord leases it to someone else and gives you proper notice that you have to leave. That was important for the purposes of adverse possession. We said the period doesn't start running at the end of the lease automatically if you're in a tenancy at will. For the purposes of computing the statute of limitations period, that will apply to the acquisitive prescription of that by adverse possession. Periodic tenancies mentioned there, same thing, right? When the lease ends and it becomes for a set period of time, a periodic period of time. Okay, then you have the case of highway properties, which is about the ways in which you can terminate a lease. By default, you cannot, right? So the lease will go on for whatever period is provided for, and that's the end of it. So if the lease is for, say, 10 years, that's it. You got to pay for 10 years. There's no, I don't have any money. There's no, I don't feel like it anymore. It doesn't work that way. You have a contractual obligation to pay. It will be an amount per month, right? They can't ask you to pay everything now, but you'll have to pay that upon the full term. So you've entered into a contractual obligation of a really large value. So if it's for 10 years, it might be, say, 200 grand. You have contractually obliged yourself to eventually end up paying 200 grand. That's it. It doesn't get changed unilaterally. So by default, you cannot end a tenancy. The corollary of that is that the only way you can is by mutual consent. So the landlord doesn't get to say, I want this over if you don't agree. You don't get to say, I want this over if the landlord does not agree. However, if you have a contractual breach, it will in some circumstances terminate the contract, right? Because if say you stop paying, for example, then usually the contract will say after 3 months it's over, because the landlord only lets you be there because you pay. Otherwise they have no interest. You're not there because they like you, you're there because you give them money. If there's no contractual provision, then you'll have the regular contract law principles apply. If it's a small breach, you'll have to sue upon contractual breach. If it's a big breach, you can count it as a fundamental breach and deem the contract terminated. That's the situation we're under. What we call a fundamental breach, not important for our purposes. If it's a big breach and it qualifies, as you'll see from the highway properties case, you have a bunch of options as the landlord, which will determine essentially the amount of damages that you can claim. So the amount of money that you can try to get. And for our purposes, it's not important what's happening in the case, right? But you have a breach that counts as a sufficient breach under the contract. Then the landlord starts asking for a bunch of stuff, right? The taxes, the fees, and the rent for a period of time if they were trying to find a new tenant. And the case is important only for the purposes of, right, establishing the principles that happen when you do have a sufficient breach, and therefore you have to determine what the rights of the parties are. So, first option is to do nothing. So, for example, your tenant stops paying. Do you have to cancel the lease? No, you don't, because we just said you don't. We said it is a contractual obligation for a set period of time that therefore can only be terminated upon mutual consent. So you have to have your tenant agree. If your tenant does something really bad, they stop paying, you can count that as a sufficient breach for the purposes of canceling the lease, but you don't have to because you choose to, because you can, or you don't, right? Again, because you have to have mutual consent. You have to have both parties agree. First thing you can do is do nothing. And so you can sit on your butt and wait and then claim it. So after 12 months or 13, or as it keeps rolling on, you can sue the tenant for whatever amount is owed. Second, you can treat it as terminated. So you can say, it's over, and then it's over, which means you'll be able to do one helpful thing, which is to repossess the property, because again, it's over. So there's a contract that says tenants there when they give you money. Then they don't give you money for a sufficient period of time. You say contract's canceled. Well, if contract's canceled, you no longer have the correlative obligation to the payment, which is to give them possession of the property. So you can take back possession. You can kick them out physically. That's helpful if that's what you want to do. But then the lease is over. So if you want to sue for money, you can only sue for the amounts that have accrued. So the unpaid rent so far is what you can sue for. That's it. Because it's terminated. You can't say, well, it took me another 3 months to be able to rent the property. That's your fault. It's because you stopped paying and I had to cancel the lease. Doesn't work that way. You can only sue upon the contract. You can only sue for the amounts accrued that were owed at the time of termination, not for your damages incurred after that, because these damages have not essentially arisen under the contract. Okay, third option is to relet it on behalf of the tenant. So you can say that you are repossessing the property. On the tenant's behalf, you will try to lease it. How is that helpful? Well, you get possession as you did earlier, but on top of that, you get to basically, you get to let it to someone else, but you get to claim your damages in the meantime. As you're doing that, rent will be owed, and you'll be able to have that fault imputed to the tenant, and therefore the tenant will have to pay for these damages. There are a number of issues that arise out of that. For example, if you lease it for more money, you'll encounter specific issues, because then essentially you've profited from that. So you'll make more money later on, therefore, you kind of compensate your earlier losses, and then you have, these problems described in the book. But by default, to the extent that you let it for substantially similar terms to another person, then you'll be able to claim these damages from the tenant. So you'll get possession, and you'll be able to claim whatever damages you incur in the meantime as well. And that's all, the three options there come out of the case. Okay, then you have the duty of mitigation, which is not directly mentioned in the case, but which is relevant. Essentially, that is again a contractual obligation. So it's an obligation that arises of general contract law principles within the common law. So in other words, is made up by the courts in England 200 years ago, and as they went after that. You have essentially the landlord, if they have, for example, a tenant that they know to be solvent. So someone stops paying the rent. Usually what you want to do is kick them out as soon as possible, so then you can get someone else, and that someone else will pay the rent. That's what you want. It might be that your tenant has stopped paying the rent because they don't feel like it, but they have the money. Your commercial tenant. So in that context, it might not be interesting for you to lend it quickly because, say, the market conditions have changed. Now, if the market's bad, you'll rent it out for less money going forward. So your advantage is to use the third option there. Say, I'm repossessing and letting it on your behalf. I'll let you know when I'm done with that for the matter of computing your damages. But then you don't really make an effort to do that because you'll lose money anyway. And as you are waiting to lease it out for less money, your earlier tenant, who you know has money, so you'll eventually get that money, is accruing an ongoing obligation bigger and bigger to give you money, to compensate you for your losses. That is the kind of thing you try to avoid with the duty to mitigate. The duty to mitigate says you can't do that. You have to make, when you're in that circumstance, a sufficient reasonable effort to stop incurring damages. So In that example, you are incurring ongoing damages. Every month, the obligation keeps growing. So you're incurring ongoing damages. These damages, right, you have an obligation, as you're incurring them, to incur them legitimately by making a reasonable effort to stop incurring them, by finding a new tenant. So the earlier tenant, the person you're suing, the debtor, will only have to pay you to the extent that you've met that obligation, right? So they will pay you this ongoing damage stream, this amount that keeps growing, but only to the extent that you've met your obligation to try to stop that. Okay, then you have a section on residential tenancies. As I said, they are usually regulated differently because they're places where people live, right? And so you don't want people to be kicked out. You want people to have a sense of belonging, not just people who are able to buy a house. So you have a bunch of specific provisions. For our purposes, the important stuff is that, as I said, it is regulated by statute. So you have an act in Ontario, but in all other provinces as well, that regulates residential tenancies. So it is still a leasehold estate. It is an estate in land, right? Again, you can register, have the various rights attached to it. But in contrast to a commercial lease, as I said, that's where the characterization becomes important. You have specific obligations that apply by virtue of the statutory regime. So as we said, right, someone passes a law, the law has various obligations. That's why a residential lease is different. Usually these obligations will seek to protect tenants for the reasons we mentioned, and usually they are public order rules. Namely, you cannot derogate from them. So they're not just default rules as you often have in statutes, right? So often the statute will provide for a rule that's a default. So we'll say, if you didn't think of putting that in your contract, that's what the default is. For example, on corporate shares, for example. However, you can deviate from that by contract, right? You can freely contract, and that includes out of these default obligations. That's not the case for most obligations that regulate a residential tenancy, and therefore they are what we call public order rules. They are rules that you cannot contract out of, even by agreement. So even if you have the landlord and the tenant both agree, it's not sufficient. The rule just applies anyway. So how do they agree, right? They sign a piece of paper that says that. A piece of paper is not valid to the extent of the inconsistency with the act. And some of these obligations are mentioned at page, in Ontario, it's the Residential Tenancies Act. I think I mentioned that earlier. 438, right? For example, you cannot, as the landlord, decline to reconduct a lease for any reason. So if you have someone who's in there and they want to stay in there, they can, right? There's very limited reasons why you can decide to kick them out. One of them is to occupy that unit personally or for a close family member. But you can't, for example, just say, right, I'll kick you out because I'll get more money on the open market because you've been there for a while. It doesn't work that way. Same thing for, right, rent increases, which are usually regulated by statute. So first you'll have a limited ability to raise the rent. If you want to raise it more than something like inflation, you'll have to provide specific justification for that. And the statute also creates usually the rental board, right, which is called different things in different provinces. Same concept, creates a place where people get to sue. That's usually cheaper because you won't go to court for $1,000. And that place usually takes care of applying these obligations as well. For example, by setting the rent if, right, there's disagreement as to a rent increase that is deemed unreasonable by the tenant. And I think we will stop there for this week, which will be plenty with the quiz.